Good evening, everyone.
Good evening.
Good
evening.
evening.
I see everybody is here and on time. You're sending me a message. No, yes. Okay, yeah, it's on. Okay, well, let's start Unit 6, Module 6, which is talking about the mortgagee's duty, their liabilities, and rights. So we know that the mortgagee themselves are a financial institution. And in that regard, when you apply for a mortgage, you have the banker-customer relationship. And that banker-customer relationship is a contractual one. So that means that you are the creditor and the bank is the debtor. And it is in reverse when you obtain a loan. And that was established in the case of Foley versus Hill. When in any contractual relationship, there are always terms and conditions. And in those terms and conditions, they can be expressed and they can be implied. And most of these terms were established in the case of Johansson versus Swiss Bank Corporation. So in a banking relationship, there are general duties. And those general duties are contractual duties. And that is that the bank carries out its action as an agent of its customer. And that, hello? Okay. And that is not limited to carrying out its customer's instructions promptly and without exceeding its authority in obeying the mandate established at the commencement of the banker-customer relationship. But in addition to all of that, the bank has a duty of care in tort. And that is also in cases there is any negligent action or misstatement by the staff of the bank. And the case for that was Headley Byrne. These cases in this section, you don't have to remember because they're all banking law cases. So one of the main features of the banker-customer relationship is that it is a fiduciary one. And a fiduciary one means that there is loyalty, confidentiality, and is built upon trust. And enshrined in the banking relationship, there is that duty of confidentiality. And in common law, that was based on the case of Ternier versus National Provincial, where the bank relayed information to the client's employer, stating that the employee gambled. And the client sued the bank. And based upon that case, it was established that a bank has a duty of confidentiality, and that confidentiality can only be disclosed in certain circumstances. And those four are: one, when there is a disclosure under the compulsion of law. So that covers when you have to file an SDR or a UTR, or you have a request from the Attorney General's office, or there is a garnishee order by the courts. The second disclosure can be if it's in the public's interest, which means that the bank then decides that there is information or some transaction that in their view, it is for the wider public to be aware of. The third one is when it's in the bank's own interest, which means the bank is looking out for its reputation. And the fourth one is disclosure can happen when you have express or implied consent from the client themselves. So which means that there is an express term in your contract, or it is an implied one based upon the relationship between the customer and the bank. So a bank is also required to provide a statement of account to the customer periodically. And the customer is not obliged to check the bank statement for errors or omission. But over time that has changed. You could look at the Bahamian case of Makushla Pinder versus Scotiabank, where in the first instance, she won the matter against Scotiabank. And on appeal, the court then reversed it and said that she was at for the funds that went missing from her account. So a bank itself has general rights. One, it has the right to charge a reasonable commission for services. And that reasonableness is where the central bank advises all of its licensees that they have to give adequate notice to its clients that it is changing its fees. The second is it has the right to demand repayment of any loan, borrowings, or overdraft that is made to the customer on their current account. They also have a right as a bank to exercise a lien over any securities that are deposited with them, other than items that are held in safe custody, that means in the safety deposit boxes. They have a right to be indemnified for any expenses or liabilities incurred while they act on behalf of the customer. And they also have a right to return any unpaid checks where there is insufficient funds. Because remember, whenever a client has insufficient funds and they write a check to the bank, that means that you are requesting an overdraft, or what they would call in banking law a loan. And the bank has the right to either say yes or say no. The other right is they have the, hello?
Hello.
Yes, Siobhan.
Hi, sorry again. I just realized my all this time I was here, this thing was on mute. I was wondering my class was gonna start and I just checked the laptop. Sorry.
Okay. So the next right is the right to exercise the right of set off when the right is under certain circumstances, and that's to take a credit balance on one account and set it off against a debit balance. So the bank has an automatic right to do that. And the bank also have a right to combine accounts. So the duties and the rights of a bank must be recognized and discharged in the context of the duties and rights of the customer in order to maintain a sound contractual and fiduciary relationship. So what are the duties of a customer? One, that is to pay reasonable charges for the services that are rendered by the bank, to issue checks only if you have sufficient funds available, and third, to exercise reasonable care in drawing checks to avoid fraud or forgery or misleading the bank. The customer also have the right to repay funds deposited on demand. They have a right to have the bank discharge its duties to them. And they also have the right to have funds deposited appropriate to a specific account to cover checks that they wish to pay. So you can actually dictate to the bank where you want funds to be deposited if you have more than one account. Now, there are specific rights of the bank as a mortgagee. And then one of those rights is the right to possession. A legal mortgagee is entitled to possession of property as soon as security over the property has been executed, and even though there has been no default on the mortgage loan. And the case of Junkanoo Beach actually outlined that in several cases where the courts ruled that once the ink is dry, the mortgagee can actually take possession of the property. A court order is required to enter into possession if the mortgagor is in occupation of the property. And in some cases where the mortgagor refuses to leave, an eviction order is also required. And the cost of entering into possession is borne by the mortgagee. Notwithstanding the right to possession, banks are reluctant to go into possession due to the inconvenience administratively and the potential liability for any negligence, which may cause damage to the property, and also the strict duty to account for any profits and rents. The bank has a discretion to adjourn proceedings for possession of mortgage property, particularly in the exercise of their power of sale under the terms of the mortgage, where there appears to be some likelihood of that the mortgagor is able to pay any sums on the whole of the sums due and owing on the mortgage, or to remedy any default within a reasonable time. They also have the right to a statutory and contractual power of sale. The mortgagee has both a statutory right under CLPA and contractual right, that's under the mortgage loan agreement, to sell the mortgage property in the event that the borrower defaults on the mortgage under the terms of the mortgage. The mortgagee may sell the mortgage property on whole or in part, and such sale may take place by auction or private contract. Although the statutory power of sale arises where the mortgage money becomes due, it cannot be exercised until one of the following conditions has been met. 1, demand for payment followed by the default continuing for 3 months, or interest remaining in arrears for 2 months, or breach of some covenant other than the payment of principal and interest. Third, the right to additional property. Since the mortgage of land includes fixtures and anything subsequently affixed to the mortgage property, after the security has been executed, the legal mortgagee is entitled to the additional chattel, that is the furniture, etc., and fixtures. Fourth, they have the right to documents of title. First, the legal mortgagee is entitled to all the title deeds, though the mortgagor may inspect and make copies of them at his own expense. An equitable mortgagee is not entitled to the title documents unless this is stipulated in the equitable mortgage agreement. They also have the right to protect the property. Most mortgages contain terms regarding the borrower's obligation to maintain and insure the mortgage property. However, the mortgagee has a statutory and common law duty, power to prevent deliberate damage, carry out necessary repairs, and insure against fire. It should be noted that if the mortgagee goes into possession of mortgage property to carry out repairs, it must account strictly for the work done. Additionally, the right to insure against fire is only to the extent of 2/3 of the reinstatement value and does not cover other risk. The next right is the right to tax. The mortgagee, as a secured lender, has the right to add further monies to the security so that the monies are also secured. The mortgage document only has terms to provide that the mortgage secures any further advances. They also have the right to appoint a receiver. A mortgagee may appoint a receiver under the terms of the mortgage to collect rents from tenants on behalf of the mortgagor as his agent. The receiver's cost will be a debt to the mortgagor, and the terms of the appointment may exclude a bank's liability for monies it does not receive. And lastly, it also have a right to consolidate. The bank may consolidate mortgages, although banks take all monies mortgages, which eliminates the need for separate mortgages. Now, who read the case of Junkanoo Estates?
I read it.
Okay. You wanna tell us, give us your thoughts on, let me see if I can pronounce their name again. The name is so long. Starastenko, Mr. and Mrs. Starastenko, who were the ultimate BOs of Junkanoo Estates. Go ahead. And anyone else could chime in if you have any comments. Who volunteered just now?
I
Was
had a
it-
question.
Go
I'm
ahead.
sorry.
Yeah.
I am sorry, I was not present last meeting, but I wanted to know, were we supposed to read the Privy Council's clarification, Junkanoo Estates, or the Supreme Court? Not Supreme Court, the Court of Appeal.
Court of Appeal.
Okay, alrighty.
Yeah, the Court of Appeal. Okay, who's starting? Because according to the couple, this whole transaction was based on fraud. No takers? I'll start off with Mr. and Mrs., I'll call them Star. They were the controllers of Junkanoo Estates. They were also investors and traders. Their company, Junkanoo Estate, had title to a property in Long Island. in Lyford Key, and it was called the Jazz House. UBS went into liquidation in March 2015. They got the mortgage, and hold on, I have the date right here. When did they get this mortgage?
I think it was the 23rd of March, 2015. No, that's when the judgment order was made.
That's a judgment order. No. Legal mortgage. No, not that. Was it 2015? Hold on.
Their commitment letter was the 23rd of August, 2011.
2011, yes.
And then,
And they got a facility of 1.4 million. So on August 2012, UBS, in a conspiracy to defraud, offered a loan for a period of 5 years to the Stars for the purpose of investment business under the investment agreement. This is their view of what happened. In August 2012, Junkanoo had been induced to enter into a mortgage agreement for a loan, mainly for the purposes of investment for 5 years. They say that UBS gave them a credit facility of 1.4 million to Junkanoo on terms that at least half of the facility would be available for investments in futures on the Chicago Mercantile Exchange. The loan was secured through a mortgage on the Lyford Key property, and the mortgage was a part of transactional arrangements under the said investment agreement, and it was strictly subordinate to and incidental to the investment business. So you see, this is their argument. Their argument was that they entered into an arrangement with UBS to borrow 1.4 million. 700,000 was for investment purposes, and the other 700,000 was towards whatever they were going to use it for under Junkanoo Estates. They say UBS carried on the trust services for Junkanoo, where money on the investment account was held by the bank on trust for the investment business. UBS carried out or purported to carry out sales or purchases of security on behalf of Junkanoo from June 2013 to September 2013. UBS failed to perform their obligation imposed under the investment agreement. So what they were saying was that out of the half of the 1.4 million, UBS failed to provide the returns that they were looking for as agreed in the investment agreement, and hence they decided not to pay the mortgage. Because as far as they were concerned, UBS didn't fulfill their end of the bargain, which means giving them the returns that they had anticipated. So they said on October the 3rd, 2014, a money lending action to recover loans secured by the mortgage was begun by UBS in the Supreme Court. And a month later, the respondent applied for summary judgment. UBS, without reasonable and probable cause, instigated legal proceedings.
Could you say that again?
Oh.
Sorry, I couldn't hear what you said.
That's my watch. Hold on. Instigated legal proceedings where the unsubstantiated allegations against the appellants were motivated by malice, employing improper practice, and equating persecution to intimidating and terrorizing. So the Stars filed a defense on a counterclaim for unliquidated damages. And then in 2017, the decision of the Privy Council was delivered. Mr. and Mrs. Starr followed the procedure based on their lordship's opinion, while the order for possession was not enforced by agreement of UBS with the Privy Council. So in 2017, the Stars filed with the Supreme Court a new statement of claim that amounted to $1.9 million plus damages, or in the alternative, $6 million, explained by the extraordinary growth of financial markets. So they were saying that if UBS had managed the $700,000 as they had purported to claim in the investment agreement, it should have amounted to at least $6 million. And if they would receive that $6 million, then they would be able to pay off their mortgage. So what did the court decide when they went all the way back to the Court of Appeal? What was decided? Because that was their defense straight through, that UBS defaulted on its obligation under the management investment agreement. Because they were trying to get everything for free. Anyone who read it?
Can you repeat the question, please?
Now I'm saying after they went to the Privy Council, they came back. What did the Court of Appeal say to them? Because don't forget now, they were trying to sue UBS for $6 million for not having the funds that they had agreed in the investment agreement. So they wanted to sue because they're saying that if they had invested the funds as they should have, they would have by now had $6 million and they would have been able to repay the mortgage. Hence, they didn't pay because they didn't get the returns that they expected to get from UBS.
I'm not quite sure if I understand, but I see here where in the Court of Appeal, it's saying that their findings is of no avail to the appellants as there has been no basis shown for the court to interfere with the decision made by Justice Evans. And they say that the appellant's claim against the respondent, meaning UBS, sounds in damages, and their counterclaim against them remains in the court below awaiting determination. And should the appellants prevail on their claim, damages will be assessed based on such provable losses as they are able to show.
Mm-hmm. But what did the court say in terms of the mortgage itself?
Mortgage, let me see.
He said, if you look at paragraph 19, they say in the case of McLeod versus Jones was cited as venerable authority for the ordinary rule that the court will not grant an interlocutory injunction to restrain the exercise of the mortgagee's power of sale, except on the terms of the mortgagor paying into court the sum of money sworn by the mortgagee to be due for principal, interest, and costs. Breck, M.R., Cotton L.J., and Bowen L.J. in that case were emphatic that was the practice of the court. The mortgagor must bring into court the money demanded of him and sworn to be due from him under the mortgage before he may qualify for the relief of a court of equity, which means that before he could say he wants an injunction, he has to bring some money. I agree with the submission of counsel for the defendant that to allow any other cost would create havoc in the marketplace. A mortgagor fat with the mortgagee's funds who seeks to avoid the mortgage instrument when the power of sale it confers is sought to be exercised, has no right to come empty-handed to court to restrain the mortgagee. Had the rule been otherwise, it requires but little imagination to foresee how a succession of defaulting mortgagors, temporizing with technical objections, could employ the interlocutory injunction to constipate the cash flow in the mortgagee's business and frustrate its normal course with all the serious implications that entails. So you see what the court is saying. When a demand is made, if you want to come to the court and you want the court to exercise equity, fairness towards you, you have to come and bring the sum that is due. Now that you have taken the money, it is only right that the bank can exercise its rights when you don't pay. But they actually instituted a whole blog against the Bahamas on this case. On UBS and the way in which it carried out its investment arrangement. So what are some of the specific duties of a bank as a mortgagee? One is investment advice. When a bank gives investment advice or lending advice, it owes a contractual duty and a tortious duty to take reasonable care in the provision of advice, and it must not do so negligently or recklessly. And that's why you see sometimes when clients ask for information, the lower staff always say, I will refer that to my supervisor. Because you don't want to be giving advice which is incorrect. Because if the client relies on that advice and they incur a loss, then of course they could bring an action against the bank. The duty to take reasonable care in providing advice is more pronounced in instances where the banker advertently and personally assumes responsibility of giving and/or volunteering investment advice, and the customer reasonably relies on that statement made by the officer of the bank. There are, however, where the ordinary business of the bank does not include providing advice on the viability or prudence of residential or commercial projects for which the bank is lending money, the customer must make it clear to the bank that its advice is being sought and not make a mere request for a loan. In order for the bank to be under duty of care to the borrower and potentially liable for negligent advice. Banks have to be prudent and aware that in merely providing information to the customer, they are still under a duty of care to ensure that the information provided is correct. The legal principle is important since statements made by bank officers who have actual or apparent authority to make such statements in the ordinary course of the bank services without any effective disclaimer and upon which a customer may reasonably be expected to rely will attract legal liability to the bank if such statements are made without reasonable care. There are also established recent decisions that have held that a bank may also be liable for contributory negligence in lending cases to other professionals, example to appraisers and attorneys, whose advisors supported lending which caused loss to the mortgagee. The second one is exercise of power of sale. The mortgagee has a limited or equitable duty to the mortgagor and any guarantor of the mortgage's debt to take reasonable care to obtain the true market value of the property at the date on which it decides to sell. The mortgagee does not have a duty to take any action to preserve the value of the security in the exercise of the security rights ahead of obtaining possession and control of the property subject to the mortgage. The bank does have a duty to account for the proceeds of sale of the mortgage property since it is a trustee for such proceeds for the beneficial interests of the mortgagor. It must pay the mortgagor any surplus from the proceeds of the sale after the outstanding mortgage principal, interest, and all bank expenses and costs associated have been repaid. Real property tax, where mortgagee is exercising his legal remedy of power of sale and acts as the vendor of mortgage property. It conveys the mortgage property to the prospective purchaser, subject to such right and equity of redemption as is subsisting in the property by virtue of the mortgage deed. The power of sale and other remedies of the mortgagee need not be expressly transferred, since they are normally expressly conferred by the mortgage deed, and they are therefore made exercisable by the mortgagee on his assigns and will pass to the purchaser without mention. While there may be no commercial obligation by the mortgagee to pay the outstanding real property taxes on the mortgage property or incur legal and administrative costs in the exercise of the power of sale, the outstanding real property taxes represents a first charge over mortgage property. Additionally, real property taxes can be assessed for 10 years retroactively. And then I give you the section in the act. Let's look at the case of Bank of the Bahamas versus the Delavos. Who read that one? Bank of the Bahamas versus you did? What are your comments?
I had to give comments, or can I just give like a summary? Like how
You can do a
I know
summary.
Okay, so
You can give a summary.
okay, this action was taken out in the Supreme Court. Bank of the Bahamas was the plaintiff and the defendants was Christensen Delavo and Marilyn Delavo. And it had to do with a first demand mortgage. In March 2005, the Delavos, they granted to Bank of the Bahamas a first demand legal mortgage over their property situated in Seabreeze Estates. Then in February 2017, Bank of the Bahamas filed an originating summons against the Delavos seeking monies owing. The total amount was like $258,000 plus, which included the principal amount and also the interest. And they also claimed for possession of land relative to the first demand mortgage. So on the hearing of their summons, Justice Hilton, he ordered the Delavos to give vacant possession of the land to Bank of the Bahamas, along with the interest and the cost. The Delavos in 2018, they then appealed it in the Court of Appeal, and Justice Hilton ordered in the Court of Appeal that the matter return back to the Supreme Court. So now in February 2020, the Delavos filed a summons for the dismissal of Bank of the Bahamas action against them. And they supported their action with an affidavit. The court then determined that Bank of the Bahamas must provide evidence of the judgment amount owed by the Delavos. And until same was done, the judgment against the Delavos would be stayed. Now, the Delavos, they had stated that Bank of the Bahamas refused to present a proper accounting of the mortgage account. And the Delavos tested numerous discrepancies from Bank of the Bahamas. Like there was a discrepancy with the amount for the interest. I think it was like the 30,000. There was a difference in their figures. Also, what else I have here? Bank of the Bahamas also failed to show documents from 2005 to 2007, what was credited and debited on the loan account. And there was other discrepancies by Bank of the Bahamas. So now Bank of the Bahamas did not provide a proper accounting. So it is an undisputed fact that the defendants, that's the Delavos, are in arrears on the mortgage loan. Justice Binder granted 90 days for Bank of the Bahamas to provide an accounting to include the explanation of the legal fees and the stay of the writ of possession and it will continue to pay, like they couldn't do anything until Bank of the Bahamas, provided evidence to show where there was default in their mortgage. I think that's all I have there.
Okay, anybody have any comments?
I think one of the things that made Bank of the Bahamas look bad was that they actually had two separate accounting systems.
Yes.
And they had a difference in balance by 30,000, if I can remember correctly.
Let me see if I have it highlighted.
Yeah, $30,327.70. So that made it look bad for Bank of the Bahamas. So that's one of the reasons why the justice asked for Bank of the Bahamas to provide a proper accounting. But they also, the judge also stated that the defendants was still liable for the monies in light of this, because it seemed to have been a stalling tactic to delay the case.
And if you notice, in most of these cases, the bank wins because everything is based on the contract. And you could hear from the rights that the bank has. They have that right as soon as the ink is dry, they can actually make a demand. Who read the next case? Quality Business Center and Anthony Munnings. I did send that one, right?
Yes, you did.
I read that one as well.
That was very interesting.
Okay. You could start. It was really a good one. Mine is written up all over.
Yeah, in that, in looking at it, this Anthony Munnings seemed to have been one of Percy Munnings' sons. And from my recollection, he's been doing this for a number of years, selling the same property to more than one person.
Mm-hmm.
So it appears to be a case whereby he met with his lawyer, Philip Lundy, and Mr. Andrew Wilson of Quality Business Center, and in the lawyer's office. And he convinced him to purchase these properties, of which he only got a clear title to, I think, six of the properties, of which he paid them some, I think, 100 and where are we? $207,600. But he never got title for the other properties, because in the process of them doing clear titles, it was discovered that Harmony Homes, which appeared to be a part of the Sunshine Group, had already purchased these properties a few years later. So in all of this, the Harmony Homes was ordered to come to court to give their testimony. And it was discovered that at the time when Harmony Homes bought the properties back in 2002, a center title, I think it was called, was not granted to Mr. Anthony Munnings as yet. So he did not have legal rights to the property. However, there was a decision of the court that after Anthony got rights to the titles, then the properties became legally Harmony Homes properties. So Anthony Munnings was ordered to pay the difference to make up the $280,000 that was paid for all of the properties back to Mr. Andrew Wilson.
Mm-hmm. But this borderline on fraud.
Yes, it was.
It's fraud. It's fraudulent.
Also, if I remember correctly, just to chime in on that,
Mm-hmm.
I think he admitted originally $80,000 in debt. That's why they had to. That's why they went back and they did another suit or another claim or another what they call it brief for the $207,000 because he had originally admitted paying them $80,000 originally. Now, once that had been done, when they went back and they did the next submission, they came back with a 207. I think everything else was based on that. he admitted that he owed them $80,000. I guess everything fell in line for Wilson to say that he owed them the $207,000 because it was already a case of fraud.
And the minute you see these people start demanding they want to be paid in cash, that's a red flag right there. Remember, he wanted a deposit of $50,000 in cash.
Yes, he did.
That's a red flag right there.
And then he wanted also wanted how many homes to declare that how many homes was not the official owners of the property, because he never signed that was not his signature on the conveyance.
Yes,
Even though after how many homes brought the secretary into court to verify that it was a signature, and it was in the presence of herself and Mr. Franklin Wilson. So that showed that that Mr. Munnings was lying and trying to hold up the process.
Excuse me, I read through the case and I was a little bit confused as to if they did a title search, wouldn't they have found that Harmony Homes was the owner of that stretch of land?
When they did the title search, that's when they did find that Harmony Homes owned the land. But apparently the lawyer, Philip Lundy, did not do the title search as he should have before drawing up the conveyance. Okay, and Philip Lundy, as a lawyer, has been doing stuff like this for years.
Right, so that's a fault on his part.
Yeah, along with his special client, Mr. Munnings. They've been doing this for years.
Yeah, it's a racket.
Question: wasn't Mr. Lundy the lawyer for both parties?
Exactly. He was a lawyer for, I think, both Munnings and Wilson.
Yeah.
He what they call a casual friend.
Yep.
Yeah, but this is fraud. This is fraud. It was a good one though. It was a good case to see how people, I mean, in your own country, how they go about selling this land. I think it was 2 or 3 weeks ago in the papers, they were saying that they're trying to move towards registered land. Anyone saw that article in the paper?
Yeah, I saw it. I didn't get to read it though.
Yeah, I didn't get to read it either because I was supposed to keep it, but they were talking about moving towards registered land in the Bahamas.
The land registry.
Yeah. I don't know how that will work.
Because I think they basically what they were saying is it would be a good thing because it would seem to spur investment in the country.
I'm trying to see.
I think I have the I think I still have the newspaper, so I'll go back and check that.
Okay, if you have if you could send around the date, I'll be able to find it.
I think it was last Thursday, really.
I know it was a week or two ago because I remember I saw it in the paper and I was supposed to read it. But I don't remember, and it's not coming up now in the papers. I'll have to look for it. But if we do get registered land, a lot of this will go away, will fall away. But will they actually push for it is another story. Because you're talking about, instead of this long title search, it's just key it in. Someone you just key it in and the report comes out. I mean, that's not something that will happen overnight. That would take years to put together.
Wouldn't that affect our acquiring laws if they put that in place?
Fighting, of course.
Okay.
And I don't think it's not gonna be a rush, like you said, because lawyers benefit from that, from this too much right now.
Exactly. So you could imagine what will happen if we did that.
Yep, a lot of business they will lose.
Yes. And so before that could even happen, they're going to have to figure out how they're going to supplement that income before they would even agree to something like that. Because that is the bulk of their business.
Yep. Because one of the things that I always found a bit I shouldn't say strange, but I knew why. Here in the Bahamas, when you get a mortgage and you go to another bank to transfer your mortgage, you shouldn't have to be going through all of those legal fees again. That should just be a simple document to transfer title from one financial institution to the next. But the lawyers seem to have put it in place whereby, hey, every time it has to come through us so that we can get a lump sum of money. So everywhere else in the world is just one small title document that costs a couple $100 versus a few $1,000s.
Okay, I found the article. Attorney General Ryan Pinder's vowed to steer the Davis administration to comprehensive land reform, which will help alleviate obstacles to foreign direct investment. It's not for us.
Clearly not.
I don't know. Hold on, let me read on. His comment came as senators debated a resolution yesterday for the government to acquire Paris Court, which was once a public right-of-way road on the property of the current Marriott Hotel. Although political parties and administration often promise significant land reform, long-standing problems have persisted. Consistent with that pledge and without wasting time, the Cabinet of the Bahamas has agreed to appoint a public-private sector committee to review land reform issues in general with a view to analyzing a land registration system in the Bahamas, Mr. Pinder said. As we know, a fundamental engine of our economy is foreign direct investment, not only for the purpose of advancing the economic development of our country and having a wider impact on Bahamians and employment and entrepreneurism, but also in support of our balance of payment and our foreign reserves. For those in practice, I am sure they can confirm that for far too long, the government approval agency, the Bahamas Investment Authority, and primarily the National Economic Council of Cabinet, has operated in an ad hoc manner with a lack of transparency and predictable meetings and approvals. This has created unnecessary delays and concerns with respect to developers and inbound investment. This, unfortunately, has been the modus operandi for multiple administrations. Mr. Pinder claimed the problem worsened under the previous administration. In the PLP's Blueprint for Change, we pledged to reorganize the approval process and promotion process for inbound investment in the Bahamas, creating a more robust structure with greater compliance, oversight, and more timely and transparent approval processes. Again, the Prime Minister and his government have wasted no time in the fulfillment of our mandate to the Bahamian people. The Bahamas Investment Authority is putting together its compliance unit as we speak to address enforcement of obligations of developers to the Bahamian people. I told you it's not for us. The Cabinet of the Bahamas has appointed a subset of cabinet members to operate as the National Economic Council, who meet on a routine basis independent of cabinet to address foreign direct investment proposals. The cabinet has likewise agreed to a streamlined approval process whereby more innocuous applications can be addressed in-house with a report to cabinet, while the material high investment decisions can be fast-tracked to the National Economic Council. This is in fulfillment of our mandate to the Bahamian people to provide a framework for more expedited investment project approvals, which means that shovels in the ground and the impact to Bahamians is enhanced and expedited. In regard to the resolution, Mr. Pinder said the government will acquire Paris Court, then swap Paris Court for a BPL way leave parcel of equal value plus $10. So What do you gather from that? A
I
comment?
definitely think
Go
a lot of things we do are influenced by the potential foreign direct investment, but I think regarding the whole discussion about attorneys not having to do the whole title search and then therefore won't have to charge exorbitant legal fees. I think we should look at it from a different perspective. We
I
being attorneys, you will get more, even Bahamians purchasing property because they don't have to pay heavy legal fees. And it's not like you're gonna do it for free. So you're still getting legal fees and you could potentially get more than what you're getting now because there are more persons willing to purchase property. And then also it's a quicker process because now you don't gotta go through the title searches, and then also the potential for like negligence because you would have like not raised the proper requisitions or done the proper searches is diminished because now these things are put in the hands of, let's say, the government or the regulatory department that's responsible for building this registered system. So I think unfortunately, we kind of short-sighted
Mhm.
as attorneys because we just see the potential of legal fees decreasing, but I think it could be a whole big benefit to us as a community if we would get that registered system, but yeah, they've been saying that for quite some time now.
I'm about to tell you that is what the bloggers say at the end of this article. They've been saying this for quite some time. The bloggers say here, the very first comment says, if foreign direct investment allows others to own our economy, encourage corruption through kickbacks, and control the workforce, while not allowing Bahamians to have as great a share in the economy as we should have. We need to move away from that business model and diversify the economy locally in order to better control the volatility of our local market to external forces. When you listen to what he said, what did he actually say this is all about? This land registration is to speed up the process for foreigners who want to purchase land in the Bahamas.
So I was going to ask a question, but I think Ms. Raming really clarified it for me because I was trying to get a better understanding on the registered and non-registered. I guess the register line would be that we'll have a system in place to be able to identify who owns the land.
Yes.
Because currently we don't have anything, I guess, no system to say, just pull it up to say that, well, this land is owned by Ms. Archer.
Yeah.
So to avoid all of the fees that we pay these lawyers to do the background
Correct.
search that goes back 30 years.
Correct.
Okay.
So that's what registered land is. Other places have it around the world. If you want to know, if you pass a piece of property and you want to know who owns that land, all you have to do is key it in and you'll know exactly who owns it. Whether it's the
Crazy that we don't
crown.
have that, though.
No, we don't have that.
That's crazy.
Everything
I guess
requires you to go and have a search done.
Okay.
And I think the UK, they got a registered land system, I want to say from 1925. So,
But this could have been done a very long time ago. Like I was saying, Turks and Caicos right down to the bottom. Here has it.
I think it's maybe because of, I think it's politically affiliated because, so many people inside, the politics are lawyers and stuff like that. So I think they're gaining so much from it with this whole search of every time you want to purchase a land or anything, there's going to be a charge. I think so much people are benefiting from it. I think that's maybe the reason why they're prolonging this whole process of the registered land.
Yeah. If we go 2 years back in time in the Tribune, 2018, the realtors hailed the government's land registry plan as taking the Bahamas to first world status, but warned it will take 20 years to get straight. So this was with the previous administration when they started talking about it. Mike Liburn, Caldwell banker Liburn, Realty's president said the goal unveiled by Ellsworth Johnson, Minister of State for Legal Affairs, means you can go to a certain location and see who owns a piece of land. And they applauded it at that time. Say, but it's still going to be a damn mess because there's so many pieces and loose ends to sort out. It would take 20 years to get it straight. So now the present government is now coming last week saying the same thing that was said 2 years ago. It's because it's what the Bahamian people want to hear. And it was all tied to the ease of doing business in the Bahamas. That's what it's about. It's not about you or I. It's about the ease of doing business. So what are some of the liabilities of a mortgagee? One is undue influence. So this is when one party has obtained a benefit by reason of the exercise of influence over another person, which is manifestly disadvantageous to the other, but they will be set aside and considered void or voidable. Undue influence is normally based upon and carried out in the context of special relationships where trust and confidence exists, such as husband and wife, or parent and child, doctor and patient, banker and customer. Banks should be particularly aware of the concept of undue influence, as a third party, spouse or parent or child may grant a guarantee or other security to it over the family home to support the borrowing of the contracted party or primary borrower of the bank. If the primary borrower defaults and the bank commences proceedings for possession and exercise of the power of sale, the guarantor may allege that there was some undue influence, either wielded by the primary borrower over the guarantor, or they could say the bank itself. To mitigate against the risk of undue influence by the bank and by borrowers, the guidelines in the case of Barclays versus O'Brien and Credit Lyonnais versus Birch are instructive to banks with regard to advising the surety or guarantor to seek independent legal advice before agreeing to act as surety or guarantor, and/or distinguishing relationships may have undue influence existent and acting accordingly. Next, it could be a mistake. A mistake will not affect the validity of the banker-customer contract unless there is a serious mistake of fact. A mistake may be made as to the subject matter of the contract, the signing of written documents, and the identity of the parties. Where a mistake is proven to have occurred, the contract is considered void. In order for a bank to recover money paid by mistake, certain conditions must be satisfied. 1, the bank pays the customer's money to another person under mistake of fact, having believed the signature was genuine, or having believed that a payment has not been stopped. There is no requirement to prove that the bank was negligent in paying the amount, only that it has been mistaken in doing so. Second, the bank pays without the customer's consent or authority, particularly where there are insufficient funds, believing that there are sufficient funds to cover payment, or pays a stop check, believing no countermand is in place. Third is then the bank pays a check and later attempts to recover the funds, but does not act with great speed. However, a bank may not be able to recover funds where A, it made a representation to the payee that it was making the payment, and the payee changed his position in good faith, and to his detriment as a result of receiving money, or B, it paid another bank as a collecting agent for the payee, and the payee has withdrawn the funds. The paying bank can only collect from the payee, not the collecting bank. Where the paying bank is unable to succeed in recovering the paid funds due to a mistake of fact, it may be able to exercise and enforce its proprietary right to trace the funds. A customer is also entitled to reclaim monies paid under mistake of fact. Where a bank has mistakenly credited a customer's account, it may redebit the account or reclaim any funds which the customer has withdrawn from the account. However, the bank may be stopped from recovering the funds if the customer changes his position in good faith as a result of the credits mistakenly made by the bank. Misrepresentation. This is a false statement of material fact made by a party to a contract or his agent, which induces the other party to enter into the contract. There are three types of misrepresentation: innocent, negligent, and fraudulent. Innocent misrepresentation is where there is a false statement made by a person who had reasonable grounds to believe that it was true when he made it and at the time when the contract was made. A negligent misrepresentation is a false statement made by a person who had no reasonable grounds for believing the statement to be true. And fraudulent misrepresentation is a false statement by a person who knew it to be false or believed it to be false, or who recklessly did not care whether it was true or false. The parties to the banker-customer contract may rescind the contract where any of the foregoing types of misrepresentation exists, and damages are available for fraudulent misrepresentation under the tort of deceit. Next is negligence. Negligence is a tort where there is an omission to do something which one has a duty of care or obligation to do, but fails to do so. In order to prove negligence, the defendant must have owed a duty of care to the plaintiff. The defendant must have breached that duty to the standard of a reasonable man, and the plaintiff must have suffered some loss or damage as a result of the defendant's breach of duty. Banks must be careful to avoid negligence by making negligent misstatements. For example, where there is a special relationship between the parties and one of the parties relied on the particular skill of the other party and suffered some loss, and that other party knew of this reliance, and professional negligence. Example, financial advice or information is given to a third party. So what are the duties, liabilities, and rights under the Homeowners Protection Act? There's an obligation to give notice prior to exercising the power of sale. The mortgagee must give a 30-day notice in writing prior to either instituting court proceedings or exercising non-judicial power of sale. In the case of court-instituted proceedings, the court may, as it sees fit, upon expiry application by a mortgagee, vary the method of service of the notice on the mortgagor. The duty of fair dealing. In the exercising of the power of sale, the mortgagee must not exercise in unfair, deceptive, or abusive acts of practices. Conditions on exercise of power of sale. Where a mortgagee has failed to secure a sale of the mortgage property at a market value within 6 months of either issuing a notice of default or having obtained vacant possession, the mortgagee, at its option, may serve notice that it intends on accepting the highest qualifying bid offered in writing. The notice must include that the property may be sold at less than the market value and that the mortgagee may pursue the mortgagor where there is a residual debt after the sale. The mortgagee may be barred from pursuing the mortgagor where there is a shortfall in sale proceeds if at the date of the sale either a sum equal to or at least 1/2 of the principal and accrued interest has been paid to the mortgagee, or the mortgagor has been in occupation of the dwelling house for a period of not less than 50% of the original mortgage term. Within 10 days of the receipt of the mortgagee's notice, the mortgagor has the right to issue a notice of objection, stating his intention to either pay the amount of principal and interest at a specified time, remedy any default consisting of any breach of any obligation arising under the mortgage, or to apply to the court for relief. Should the mortgagor fail to issue a notice of objection, the mortgagee may take the required steps to sell the mortgage property. The provision of this section shall apply to all mortgages, notwithstanding any provision in any other law or custom, or any clause contained in any mortgage document executed before or after the coming into effect of this act. Prohibition against sale to related parties. The mortgagee shall not sell the mortgage property to any of the following parties: a director or employee of the financial institution, an immediate family member of a director or employee of the financial institution, a company beneficially owned by a director or employee of the financial institution, or any person who, by the nature of their intimate relationship with a director or employee of the financial institution, would be given more favorable consideration as a result thereof. The conveyance from the mortgagee to a purchaser pursuant to the exercise of the power of sale must contain a clause reciting the mortgage document and that the mortgagee has exercised his right to sell after giving notice to the mortgagor. The effect of the above recital is to bar all equity of redemption of the mortgagor or his successors in and to the mortgage property. The mortgagee shall be exempt from paying 50% of any sum due and owing under the Stamp Act on the sale of a mortgage property in instances where the mortgagee sells the property under the power of sale within 5 years of the date on which the last advance was made by the mortgagee. The mortgagee must respond to a mortgagor's written request for a statement of account within 30 days of receipt of the request. The mortgagee must supply the said statement free of charge up to twice in any calendar year. If the mortgagee fails to respond without having a reasonable excuse, any rights which it may have for the enforcement of the debt will be suspended until it has been complied with. And this relates only to those proceedings initiated after the coming into effect of the Act. Where the mortgagor exercises his entitlement under Section 17 of the CLPA, the mortgagee must assign or convey the debt to the new lender without requiring the mortgagor or the new lender to pay any costs associated therewith. If a mortgagee transfers, assigns, or sells the mortgage's debt, the mortgagee must advise the mortgagor in writing not less than 30 days before the effective date of the transfer, assignment, or sale. And the notice must be served either personally or by registered post. A financial institution that contravenes or fails to comply with any provision of the Act commits an offense, and the fine is $200,000. A director of a company who knowingly concurs or contravenes or fails to comply with the provisions of the Act, again, is an offense, and the fine is $100,000. So notwithstanding any penalties that may be imposed, the financial institution that contravenes or fails to comply with any provision of the Act, there's a fine of $200,000. A director of a company who knowingly concurs in a failure to comply, there's also a fine of $100,000. And judgments and expiry dates. Previously, judgments granted by the court with respect to mortgages were not subject to any expiry date. However, with the coming into effect of the Act, mortgagees are statute barred from recovering any sum owing under such judgments after either the expiry of 6 years from the date on which the judgment was obtained or the date of the last payment pursuing to the judgment. And so now you see a lot of mortgages that are nearing that expiry of 6 years. A lot of those banks, those financial institutions are now hurrying to make sure that they have the properties sold before the expiry of the 6 years. Any questions or comments? Any comments on the Homeowners Protection Act and the bank's rights and its duties? If anyone is interested, I can send you from a banking perspective, which is a good case to read. It's not mortgage related. The case of Makushlapinda versus Scotiabank, where there were withdrawals from the savings account, and which she won at first instance, and on a second instance, the bank won.
Ms. Archer, in that case with the Kushlapinda versus Scotiabank, wasn't it the bank's right of offset why they won?
Yes. But at the first instance, the court was saying that it was fraud. Because she was saying that she did not withdraw the funds. The funds were set up for savings, and she was not aware that she was supposed to check her account.
Okay, because why am I, because what we just read earlier, I guess contradicts all of what she's saying, because you just mentioned that the bank has the right of offset and the right to add loans and whatnot together, or under the rights of a bank. So I can't understand why the bank would have given it to her originally and then come back and I mean why the courts would have given her give it to her originally and then turn around on the instance of appeal, say no, that ain't what it is. You know, so okay.
Yeah, but I can send you the case.
Okay.
2000, yeah, 21. She was, the bank was ordered to repay her $27,500 in unauthorized transactions. Because she claimed that she was traveling when these funds were taken off. She claimed she didn't know the persons who took off the funds. And the court then said that the bank had to pay her monies back. And they were negligent.
Okay.
In allowing the funds to be withdrawn, even though she had reported it.
All right.
Yeah, but I can send you the cases.
Thank you.
The case.
All right.
So you could, yeah, okay?
Yes, ma'am.
All right.
You can send it to me as well, Ms. Archer, sorry.
Okay, so send it to Ashley, and who was that just now, Kenneth?
That was Kwame. Kwame. Yeah.
Okay.
And send it to me too.
You can send it to Kenneth as well.
Okay. It's a good case to read on. This is a Bahamian case. Okay, all right. Well, that's it for us for tonight. I gave you all an early night off, which is wonderful, isn't it? Those who haven't read this, they can read them because you will see them in the final exam.
Ms. Archer.
Yes.
You got my name to send it to me too, please?
Yes, I did.
Thanks.
What is it that you said we need to read if we haven't read it? You're talking about Junkanoo Beach?
All of the cases so far.
Okay. Is it possible that we can get a list of all of the cases just in the event that we didn't make note of them?
Yes, I can do that.
Okay, I would appreciate that.
Okay, all right. That can be done.
Thank you.
Okay, not a problem. All right, because I know everybody is busy, so you normally don't have time to read it. But you need to start reading it now as we narrow down. We have, let me see. Yeah, because more cases to come. So I would think you should start to prepare now by reading all the cases that you didn't have time to read. So you can prepare. So I'll prepare a list and send it.
All right.
Yeah.
And any that you're missing, you can just let me know.
Okay.
Thank you.
Okay. All right, not a problem. Go ahead.
Sorry, so we're not having a midterm exam?
No, just one final exam.
Okay.
Yeah.
Which date is the exam?
April the 23rd.
Okay, thank you.
Okay, the last day of class is the 4th, and the final is on the 23rd.
That's the 4th of April?
Yes.
All right.
And they're all scenario questions.
What you mean by scenario questions?
Short answer, short essay type questions.
Okay, thank you.
Okay. So I'll make a list and then I'll send that, and then anybody who's missing any could let me know. So I can put it together for you. Okay?
Thank you. Thank you. In that case, could you send me last case that you are discussing just now?
Oh, the Makushla one?
Yes, ma'am.
Yeah, okay. I might as well just send it to everybody.
Thank you.
Okay, all right. I'll send it to everyone. I'll send you. I'll send it to everybody. Along with the newspaper clipping with the summary of it. I'll do that.
All right, thank you.
Okay. So have a good evening. You have an
You
early
too.
night. Start to organize yourself. And so when I send the list, you'll know which missing. Okay, so have a good evening.
You too.
Okay.
You too.
Good night.
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 Good night.
Night.